Mr. Wheeler make him any promises in order to get him to talk to you?
No, ma'am.
And what about threats? Did you threaten him in order to get him to talk to you?
Absolutely not.
And did Officer Wheeler do any of those things?
No, ma'am.
She didn't threaten him?
No.
No further questions.
All right, thank you. Ms. Briggs, cross-examination.
Thank you, Judge.
You're welcome.
Good morning, officer.
Morning, ma'am.
I'd like to direct your attention back to sort of the point in the process where Mr. Willoughby was standing on the balcony and you were downstairs outside of the apartment.
Yes, ma'am.
Okay. Now, when Mr. Willoughby was standing on the balcony, you testified that you began to explain to him that the Long Island Police Department had probable cause to arrest him, correct?
Yes, ma'am.
And in response to that, you had testified that he had made a statement about how it was actually reasonable doubt to place him under arrest, right?
Correct.
So it was clear that he had heard the statement that you had made to him about there being probable cause to arrest him.
Safe to say.
And he responded to that.
I don't recall the video, but I believe if that's what you're telling me.
Yeah, and you just told us that he made a statement in
Yeah,
response.
he did say about the reasonable doubt. Yes, ma'am. Sorry, I misunderstood.
Sorry, that was kind of a bad phrase.
That's
but-
okay.
And at that point, then, you actually informed Mr. Willoughby that he was under arrest.
Correct.
Could you describe for us, you had spoken with Ms. Kelly a little bit, but what was his demeanor like at that point?
Still kind of escalated. Didn't seem to fully understand why he was under arrest, what the allegations were.
And tell us a little bit more about that. When you're saying he didn't seem to fully understand why he was under arrest or what the allegations were, what do you mean by that?
He had made a statement that she cut up her own driver's license. He was trying to remove the scissors from hurting herself. He also, I believe, made a statement about nothing physical had happened, and that's why I was explaining in Colorado it doesn't have to be physical for a domestic violence charge.
So it appeared to you that, and I don't want to put words in your mouth, but it appeared to you that he did hear the statement that you were under arrest. He was just quibbling with you, or that's my word, but was sort of disputing the, like, why is this happening? Is that accurate?
Sure.
Okay. Now, at that point, after you had told him that he was under arrest, you and him additionally engaged in some further interaction, and that was the statements that you had relayed earlier, where he was indicating that he had evidence that he wanted to show you, right?
Correct.
Okay. And you responded to him and said, quote, "I'm not going to lie to tell you you are not going to jail, but if you are willing to let us go in there," meaning inside of the apartment, "to look, and it proves your side of the story, then it will probably change you going to jail, but I can't tell you one way or the other," correct?
Yes, ma'am.
Okay. And at that point, then Mr. Willoughby, you had gone up to the apartment doorway
Yes, ma'am.
and had entered the residence.
Correct.
Okay. And prior to that point, Mr. Willoughby had been expressing consistently that he did not want officers entering his apartment.
Correct.
Once you had actually entered the residence, you had spoken about how you were inside of the residence. There was another officer at the door, correct?
Yes, ma'am.
And the door was open?
Yes, ma'am.
Which officer was at the door?
Initially, it would have been Officer Doug Holliday.
And in relationship to the open door, where was Officer Holliday positioned? Was he standing in the doorway, to the side of the doorway? Describe that for us.
I believe he was in the doorway or off to the side. I wasn't necessarily watching him, so I can't accurately say. And to be honest, I did not view his body camera.
Okay. Other than, actually, I'll rephrase that. Is that doorway the only entrance exit into the apartment or from the apartment, other sort of jumping over the balcony?
To my knowledge, yes, ma'am.
Okay. And then you described to us that a bit later, then Officer Wheeler had also entered the apartment.
Correct.
During that period of time, where was the fourth officer, Officer McNulty?
He was still outside.
Specifically, do you know where he was outside?
I don't. I would assume he was still down on the first story out by the balcony, or he'd come up to the landing out of sight, but I can't accurately say.
Okay. Once you had made entry into Mr. Willoughby's apartment, you had testified that you guys were having a conversation and he was sort of walking around and showing you things inside of the apartment, correct?
Yes, ma'am.
At any point after you had entered the apartment, did you inform Mr. Willoughby that he was no longer under arrest?
No, ma'am, I did not.
To your knowledge, did any other officer, including but not limited to Officer Wheeler, inform him that he was no longer under arrest?
No, ma'am, not to my knowledge.
Did you inform him that he was free to leave?
I did not.
Did any other officer inform him that he was free to leave?
No, ma'am.
Did you or any other officer inform Mr. Willoughby that he had actually shown you evidence that would have changed your decision about whether or not to arrest him?
I did not, and I don't believe any other officer did.
When you were speaking with Ms. Kelly, she had asked you some questions about the tone of the conversation. Do you recall that?
Yes, ma'am.
And you had testified that generally, with the exception of telling Mr. Willoughby that he was under arrest, that the tone was conversational, correct?
Yes, ma'am.
How would you describe your tone of voice when you actually told him that he was under arrest?
I would say it was louder to make sure that he could hear me as he was still speaking over me.
Once Officer Wheeler entered the apartment, she began, was she asking Mr. Willoughby direct questions?
Not to my knowledge, but I did not view her video or body camera.
Okay, but she, to your knowledge, she was discussing essentially the state of the evidence against Mr. Willoughby with him, correct?
Yes.
And Mr. Willoughby was making statements in response to Officer Wheeler's statements?
Yes.
I don't know anything further, Judge, thank you.
All right, thank you. Any redirect, Ms. Kelly?
Maybe just one question, Judge, thank you. So defense counsel was asking you about two separate statements that you made to the defendant while he was standing on the balcony and you were standing on the sidewalk. One of them was, we have probable cause to arrest you. The other one is, you are under arrest. Were those two statements made at different points in the conversation?
Yes.
And when you told the defendant that you had probable cause to arrest him, what was his response?
That is when he stated that we have reasonable doubt.
And did he respond at all specifically to your statement, you are under arrest?
Not that I recall.
Okay. And during that time, would it be fair to say that he was talking over you and did not respond to what you were saying around that statement?
Yes, ma'am.
All right. No further questions.
All right, thank you. All right, you may go. Thank you for your testimony.
Thank
today.
you. Would you like me to just leave this up here, Your Honor? The video?
Oh, I actually have a copy.
You have a copy, so would you like me to take it? Actually, can you take the official one that
Sure.
has the exhibit one on it?
Oh, yeah.
I think is that okay with defense counsel?
Yeah, that's
Okay,
fine.
great.
All right. All right. Counsel, my intent is to take this under advisement. Would you like to argue this motion?
Judge, my understanding, based on a conversation that I had with defense counsel prior to this hearing, is that I think what defense counsel, and she can obviously speak for herself, is focusing on is that period of time when the officers came into the house. I think it's relevant what happened previous to that. Obviously, the statement that the officer made about being under arrest changes this entirely. I don't think we would even be here discussing it if not for that statement. What I will tell you is taking out that statement from the analysis, it's very clear the defendant at no point before he was placed in handcuffs was under arrest. All the factors that I laid out in my motion, Judge, all of the factors weigh in favor of the defendant not in custody. And what happens when that statement is made is the defendant, first of all, I would argue, looking at the body cam video, it's not registering with him in the first place. But even if it were registering to him, having not allowed officers even close to his apartment previously, his decision or his understanding of his situation at that time materially changes because then he lets the officers in. And so he actually believes, and a reasonable person under those circumstances would believe that his circumstance had changed and that he was not going to be placed under arrest. And you heard the officer, obviously subjective intent of the officer is not relevant, but the officer in fact responded to the defendant in a way that a reasonable person would believe that the officer was very willing to look at the evidence that he had. And so arrest was not imminent. Even though it was a possibility, that's not what the standard is. While the defendant is making statements, the defendant has to be in custody for purposes of Miranda, not that he's thinking he might be placed into custody later, but whether or not when the statements are actually being made, that he is restrained to the point of a formal arrest. And at no point did the body cam show that that was the situation. And so I would ask the court deny the motion, specifically with respect to the statements made while the officers were in the defendant's apartment. And if the court has any other questions specifically, I would be happy to answer them.
All right, thank you. Ms. Briggs?
Thank you, Judge. I'll be brief. What Ms. Clay represented to the court, it is correct. I'm only seeking to suppress statements that were made after the officers had made entry into the apartment. And specifically, the set of statements that I am concerned about is the statements that were made in response to Officer Wheeler's statements to Mr. Willoughby describing the nature of the evidence against him. What I would argue to the court is that obviously the court knows what the applicable test is here. Here, a reasonable person in Mr. Willoughby's position would consider himself to be deprived of his freedom of action to the degree associated with a formal arrest under the totality of the circumstances. Officers have responded to Mr. Willoughby's apartment in response to a domestic violence call. They told him that they were investigating that interaction while they were standing outside of his apartment and he was on the balcony. Officer Arces had explained to Mr. Willoughby why Longmont Police Department had probable cause to arrest Mr. Willoughby. Mr. Willoughby was at least responding to that in a way that indicates that he agreed with that statement. Officer Arces then informs Mr. Willoughby that he is actually under arrest. I would point the court then to sort of in terms of did he hear that, did he understand that, is that then the subsequent conversation that he's having with the officer about where the officer is saying, I'm not going to lie to you, you're not going to go to jail, but if you are willing to let us come in and look, then it might change something. That's me sort of paraphrasing, but I would argue to the court the fact that at that point then that he allows entry into the apartment then indicates that he had heard and understood officers telling him that he was in fact under arrest. Once the officers enter the apartment, they have an officer inside, another officer stationed at the open door. Officer Arces has testified that he was not clear to his recollection about if the officer was actually blocking the door or standing just to the side of the door. There was a fourth officer on the scene who Officer Arces is assuming, but does not specifically recall, that was either outside in the hallway or was downstairs near the balcony area out front. That door appears to be the only entrance and exit into the apartment. So while I acknowledge that Mr. Willoughby was not physically restrained within the apartment, he was never informed that he could leave. He was never informed that he was not under arrest. He was never informed that he had shown the officers anything that would change their minds about the initial arrest decision. And so at that point, a reasonable person in Mr. Willoughby's position would consider themselves to be deprived of their freedom of action to the degree associated with the formal arrest, because he had been informed that he was going to be formally arrested and nothing had changed to dissipate that impression that was communicated to him. At that point, then I would posit to the court, obviously the court has not heard any testimony that there was any type of Miranda warning given. My argument to the court would be that he was clearly in custody at that point, and that the statements that Officer Wheeler was making to him were statements that she reasonably knew would have been likely to elicit an incriminating response, given that she was directly confronting him with information about the state of the evidence against him.
All right, thank you. All right, how would you like to proceed on Mr. Willoughby's other motions? Those are the only motions that I see that are still before the court. I am going to take them all under advisement, but I'll hear argument on them. I've got, I'll just go down the line here. Motion for discovery relating to experts and opinions, motion to strike prosecution's endorsement of Gene McAllister, motion for specific discovery regarding Gene McAllister if I don't strike the motion for that witness. I think those are really the only ones that would need argument.
Yes, Judge, and so I'm fine with the court just ruling,
Okay.
which I was somewhat anticipating that Judge Zero would have done already.
Okay.
But just on D2, D3, D4, D5, D6, which are the motions that the court was just not discussing. But then I guess moving into, I guess I'll start with Ms. McAllister. So subsequently to me filing those motions, which specifically are pertaining to generally to D7 and then specifically to Ms. McAllister with respect to D8, and then alternatively to D9. After we had filed, or after I had filed those pleadings, then the prosecution did subsequently discover to my office a summary of Ms. McAllister's proposed testimony. That summary I would posit to the court, and I was intending to actually file a copy of it so that it's included in the record. That summary is 12 pages of actual summary, and then another 3 pages of what she refers to as her literature list. The prosecution has endorsed her as an expert in domestic violence victim dynamics, which is an extremely broad and vague topic. The summary that was provided in discovery encompasses the topic of intimate partner violence generally, including but not limited to the topic of power and control. The cycle of violence goes on to discuss the use of alcohol and drugs in relationship to that, who may become or is not a victim of domestic violence. Further goes on in a separate subheading to discuss strangulation and asphyxiation. Then further goes on in, again, another subheading to nature and dynamics of trauma and victim responses during traumatic events. Further goes on to talk about victim recall and reporting of traumatic events, trauma victim presentation, the nature and dynamics of victim responses following traumatic events, the impact of trauma in violent intimate relationships, and then finally we come to a subheading entitled Dynamics of Intimate Partner Violence, Typical Behavior of Victims and Offenders, which then is, in total, that subheading itself is about 2.5 pages just within that singular subheading of the document. I've cross-examined Ms. McAllister in a number of other cases. I can tell the court that this, within the scope of domestic violence cases where she's been endorsed as an expert, this is the exact same sort of like pattern, like kitchen sink summary that gets disclosed to us in every single case. It is not tailored in any way to the specific facts about Mr. Willoughby's case. It does not give me any indication about within this 12-page summary what specific topics that the prosecution would intend to actually have her opine on. Without that information, I cannot appropriately file any further pleadings related to the scope of her testimony because I don't have adequate notice about what actual opinions they're seeking to have her present within that very broad sort of victim dynamics testimony. So despite the fact that they have now produced this summary of expert testimony, it still does not alleviate the concerns that I have expressed in asking the court to strike her as an expert witness unless and until such time as they can provide a summary that is appropriately tailored and that gives me appropriate notice so that I can move forward addressing that in order to appropriately prepare to cross-examine her to give effect to Mr. Willoughby's constitutional rights to confrontation, effective assistance of counsel,